Look at this carved ivory elephant. Imagine a private collector pays £300 for it, relying on a shop owner's assurance that it's a 16th century mogul piece with genuine gemstone eyes. 6 months later, an appraiser delivers the bad news. The piece is a 19th century reproduction worth £100. When resolving a dispute like this, we first have to classify the shop owner's pre-contractual statements into one of 3 buckets. They might be mere puffs, which are obvious exaggerations carrying no legal weight. They might be express terms, which form the actual contract and trigger a breach if broken. Or they might be representations. To separate a term from a representation, courts look at the objective intention of the parties. They ask what a reasonable bystander would infer from the parties' conduct and words, completely ignoring whatever secret thoughts were going on in their heads. This initial classification dictates everything that follows. The specific label applied to the false statement locks in the exact legal remedies the buyer can pursue to recover their money. When the party's objective intention is murky, courts rely on guidelines. The most prominent is checking the relative skill and knowledge of the 2 parties, tipping the scale based on who holds the expertise. We see this play out in 2 classic car sale cases. In Oscar Chess, a private citizen sold a car to a dealer. Because the private citizen lacked expertise, his incorrect statement about the car's age was deemed a mere representation. But in Dick Bentley, the roles were reversed. A dealer sold a car to a private buyer. The dealer's expertise elevated his false mileage claim into a binding contract term. Warning tone. Examiners routinely penalize students who treat these guidelines, like a lapse of time or whether a statement was repeated in writing, as a rigid scoring system. They are fluid indicators used to deduce intent, not a math equation. A significant gap in factual knowledge dictates the court's approach. If the seller controls the facts and the buyer is ignorant, the court will elevate a casual assurance into a binding contractual warranty. If a statement lands in the representation bucket, we use this definition to see if it becomes an actionable misrepresentation. We need 2 main ingredients: a false statement of fact and proof that this statement induced the innocent party to enter the contract. Let's isolate the fact requirement. A pure opinion carries no liability, as we saw in Bissett, where a farmer guessed how many sheep a plot of land could hold. But if the speaker has superior knowledge of the underlying facts, like a landlord describing a tenant as desirable while knowing they are deeply in arrears, the court in Smith ruled that the opinion carries an implied statement of fact. Next is the inducement requirement. The false statement must actually encourage the buyer to sign. In Atwood Z. Small, a buyer hired his own independent experts to verify a seller's claims. Because the buyer relied on his own team rather than the seller, the chain of inducement was broken. You can prove a statement is completely false, but if you cannot prove that specific lie caused the claimant to sign on the dotted line, you have no legal claim. If you prove misrepresentation, the immediate equitable remedy is rescission.
Think of it as hitting the rewind button to cancel the contract and return both parties to the exact financial and physical states they were in before they met. But equity has limits. You lose the right to rescind if a third party acquires rights in the property, if you affirm the contract by continuing to use the item, if physical restitution becomes impossible, or if there is an undue delay. That delay factor is strictly applied in non-fraudulent cases. In Leaf v. International Galleries, a buyer waited 5 years to discover a painting was a fake. The court ruled the timer for delay begins the moment the truth should have been discovered by a reasonable person, blocking the rescission entirely. When rescission is barred, we follow the flowchart down to the statutory alternative, Section 2.1 of the Misrepresentation Act 1967. Notice the burden of proof. Under Section 2.1, the burden shifts heavily onto the defendant. The path then takes an aggressive turn.
The Roy Scott Trust case established the fiction of fraud. Even if the defendant was merely negligent, damages are calculated as if they committed intentional deceit, allowing the claimant to recover all direct losses and completely bypassing normal foreseeability limits. Escaping this liability is notoriously difficult. In Howard Marine, a defendant tried to prove they had reasonable grounds for a false statement because they checked the authoritative Lloyd's Register. The court still held them liable because the accurate figures were in the primary shipping documents they neglected to check. Section 2.1 functions as a massive tactical advantage for claimants. It forces the defendant to prove their own innocence and exposes them to maximum tortious liability if they fail. Let's apply this to Michael, our ivory elephant collector. Michael asked a historian friend to verify the elephant's age, meaning he relied on his friend, not the shop owner. Nat breaks the inducement chain for the age, but the friend knew nothing about the gemstone eyes. Michael relied entirely on the shop owner for that detail, making the statement about the eyes an actionable misrepresentation. Michael waited 6 months to have the elephant appraised. Under the leaf principle, a court will likely consider this an undue delay because he had the opportunity to verify the item immediately after purchase. Because of this, rescission is blocked and he cannot demand a direct refund. With rescission barred, Michael turns to Section 2.1 damages. The shop owner now has to prove she had reasonable grounds to genuinely believe those eyes were precious stones. If she cannot clear that high hurdle, Michael claims the difference in value under the aggressive fiction of fraud measure. This brings us to the master decision tree needed for your analysis. Step 1. Classify the statement. Step 2. Test the definition of misrepresentation, checking for fact and inducement. Step 3. Apply the remedies, testing rescission bars before Section 2.1 damages. Bypassing the sequence and jumping straight to damages is a trap. By testing liability and inducement first, you build a structurally sound argument that accurately applies the law from start to finish.